Gentlemen, did you not support the current law, your organizations?
Yes, we did.
We actually helped draft it.
That's what I thought.
Yep.
So, if you helped draft it, and you had that insight and ability to draft law that most average people in the state don't get, how'd you screw up? I mean, most people don't get to draft the law, but your organization got to draft it.
Remember what happened? We had the Supreme Court decision that says the EPA does not have the authority to regulate isolated or non-federal wetlands. So we came up with the framework. It considered mitigation, but really didn't allow mitigation to be widely utilized, because at that point, mitigation was largely considered junk science. People didn't think mitigation could be adequately used to protect the resource. I think over time we've seen that based upon other states and their use of mitigation, that mitigation can be used more effectively. And it's time, based on that experience, based on the 10 years or so we've had to operate under this law, we now have the opportunity to revisit it and make necessary changes.
And if I can expand on Tom's point just a little bit, that's true. And at the time, the department had a strong preference for on-site mitigation. The technology has evolved. Some of the earlier testifiers spoke to the research that's been done on mitigation projects, and the current state of the science has a preference for off-site mitigation in sites that can be permanently preserved, sites that aren't in the back of somebody's industrial park, sites that are in a better location. And I guess I'll conclude Representative Molepske with the earlier speaker from the Wetlands Association's comment that it really only makes sense to be constantly reviewing, revising, and updating these processes as we learn from what we did before. And I think that's what this is. This bill, credit to Representative Mursaw and Senator Kedzie, this bill is the next step in an evolution.
Just 2 more points, Mr. Chair, if we can. It's been stated over and over and over that there's a concern that we're turning the process on its head, and instead of the applicant, who understands everything about the project, giving its best review to the department has basically all the burden to show that the project should not go forward. Why would we want to set up a scenario that the applicant doesn't have to show that alternatives exist? In other words, if I own a piece of property that I already know wetlands on it, and of course now there's probably some diminution in value, but are you asking as associations that irrespective of the wetland that's on it, we want the law changed so that we can proceed on the development, knowing full well that that was once a public policy that said we shouldn't develop that? Because you're basically saying, if I choose this site, state, you really have to go way into an analysis to show that I should not proceed.
Representative Molepske, if I can refer you to pages 22 and 24 of the bill. On page 22, lines 20 through 23, this is for a general permit. The applicant must provide the department with a detailed explanation of why the impact cannot be avoided and how the impact will be minimized to the greatest extent practicable. Page 24, in the individual permit language, an applicant shall include in an application an analysis of the practicable alternatives that will avoid and minimize the adverse impacts of the discharge on wetland functional values and that will not result in any other significant adverse environmental consequences. That reads to me like the burden is still on the applicant.
The other point I'd like to make is that nothing in this bill limits the ability of the department to establish general permit criteria, to establish mitigation standards. All of those will be developed at some point, and so this is kind of the skeleton, and the department will have the opportunity to place meat on the bones or establish the criteria at some later date if this bill ever passes.
All right, just my last point. For the realtors, Tom, you said we should look at the catch-all on 28, line 22, number 3.
Mm-hmm.
Now the current law, there's a big difference there though. The current law says adverse impacts. Now he's saying, as long as it's not a significant impact. Wouldn't that be a fairly significant change in protection of the wetland? You can get all the way up to significant, whereas in the current law, we start warning at adverse.
I think I think without significant, any filling of the wetland, anytime you touch the wetland, there's going to be some adverse impact to it, by its very nature. I think significant raises the bar somewhat and allows the department to determine whether or not these impacts are de minimis or whether they are substantial in nature. It's part of that holistic approach.
Thanks, and I just one comment, Mr. Chair. I define holistic as whole systems rather than splitting humans in the environment. That's Webster's definition. So I think we want to be clear of that, just so at the end of the day that the environment and the humans are all they have to have that continuous cycle.
Representative